This is Barry Zalma, Zalma on Insurance. I'm an attorney who has retired from the active practice of law and now spend my time as an insurance claims consultant, an expert witness, an author, producer of these videos, and as the producer of Zalma's Insurance Fraud Letter, which is published twice a month at www.zalma.com. The current issue starts with an article I have written concerning bad faith setups, something that should be of interest to every insurance claims professional and specifically to those involved with insurance fraud. Bad faith insurance claims are successful when a plaintiff can prove that the insurance company wrongfully denied an insurance claim and deprived the insured of the benefits of the contract of insurance without good cause. Bad faith insurance suits can arise in the context of any insurance policy and any claim on any insurance policy. California created the tort by court decision. Florida, on the other hand, like many states, created the legislation that allowed the tort of bad faith to be exercised in its state. In light of the substantial damage awards attendant to bad faith claims, plaintiffs' attorneys have great incentive to try to maneuver insurance companies into committing acts that may later be trotted out as evidence constituting bad faith. They may, and fairly often do, attempt such setups by creating a situation where the insurer refuses to settle a tort claim within policy limits within a limited, usually very short, period of time. The plaintiff's purpose, of course, is to recover substantial extra contractual damages, including attorney's fees, where permitted. In short, since a bad faith verdict can be vastly more lucrative than simply collecting on a within policy limits claim, the temptation for a lawyer to take advantage of a young, inexperienced, or inadequate insurance adjuster overcomes any sense of morality or the need to obtain a settlement that is in the best interest of the lawyer's clients. With bad faith claims viewed as the gateway to recovering attorney's fees and damages well in excess of policy limits, insurers and policyholders' counsel need to be well versed in addressing scenarios in which an insurer's allegedly flawed investigation, settlement practices, and/or non-compliance with statutory claims handling requirements open the door to extra contractual disputes. While bad faith claims start with establishing some form of unreasonable conduct by the insurer, something more than negligence, a mistake, or poor judgment is required to present a meritorious bad faith claim. This holds true whether the bad faith claim rests on the insurer's alleged breach of the implied covenant of good faith and fair dealing, its fiduciary or quasi-fiduciary obligations owed to its insured, or its violation of unfair insurance practices or claims handling statutes. Some situations that can result in a bad faith suit include low policy limit and higher exposure claims, failure to settle a liability claim within limits when liability of the insured is clear, lost opportunities to settle within limits, failure to apprise the insured of material litigation or settlement developments, flawed investigation unduly focused on developing grounds to deny a claim, competing claims for policy limits, mishandled control of defense, including disregard of conflicting interests and or the insured's entitlement to independent counsel, failing to timely apprise the insured of the coverage limitations, overlooked traps in demand letters from plaintiff's counsel, insufficient attention to efforts to establish bad faith claims in a problematic jurisdiction, material violation of statutory claims handling requirements and or problematic claims file entries. Now, these setups have arisen because of the ease some insurers have made it to allege bad faith. As a result, the bad faith setup has become fairly common. The bad faith setup is not a new tactic. In 1985, Justice Kaus of the California Supreme Court observed, quote, "It seems to me that attorneys who handle policy claims against insurance companies are no longer interested in collecting on those claims, but spend their wits and energies trying to maneuver the insurers into committing acts which the insured can later trot out as bad faith." Close quote. This was a decision or a note in the case White versus Western Title Insurance Company, a 1985 decision of the California Supreme Court. Similarly, in J.B. Aguirre versus American Guarantee, a 1997 decision, the California Court of Appeal affirmed a judgment of dismissal on demur, holding a liability insurer did not act unreasonably as a matter of law in refusing to meet the plaintiff's $2 million settlement demand, despite the alleged risk of exposing the insured to uncovered punitive liability. The insured's alleged fear of his punitive exposure coerced him to contribute to a settlement out of duress. Justice Neal observed as follows, quote, "What we have here at bottom is an effort by the insured to concoct a bad faith claim out of whole cloth. With the ingenious assistance of counsel, the insured has attempted to position itself to pursue a high-stakes, bad faith case seeking punitive damages from which it hopes to emerge not only with the underlying claim disposed of at no cost to the insured, but a profit as well in the form of damages recovered from the insurer. Bad faith litigation is not a game where insureds are free to manufacture claims for recovery. Every judgment against an insurer potentially increases the amounts the other citizens must pay for their insurance premiums." Close quote. Bad faith setups most frequently originate in the third-party context, when an insurer is defending an insured against a tort claim, and there are insufficient limits available to compensate the injured party. In this case, the setup involves attempts to cause an insurance company to reject a policy limit settlement offer. Third-party claimants and their counsel have come up with various ways in which to present their offers to reduce the chance that the insurer will actually accept the offer within the stated time period. The plaintiff's goal, of course, is to obtain a sizable excess verdict. If successful, the next step in the strategy is for claimant's counsel to enter into an agreement with the insured whereby the claimant gives a covenant not to execute on the judgment in exchange for an assignment of the claim based on bad faith failure to settle. The most common form of a bad faith setup is to make a settlement demand, typically of policy limits, with an unreasonable time demand. A claims claimant's lawyer may make a settlement demand with an unrealistic time limit before the insurance company has access to the information bearing on liability and damages. The insurance company often declines to meet the demand, explaining it needs further information. This position is then portrayed as a failure to settle and will then be used against the insurance company as evidence of unreasonable conduct in the settlement of the case. In a particular case, an insured's demand letter imposed such unreasonable conditions that the Ninth Circuit Court of Appeal concluded that the insurer did not act in bad faith in not immediately meeting the demand. This was Cheriulu versus California Casualty, a 2013 decision. In assessing bad faith, the reasonableness of the conduct of the insurer's counsel must be measured against the corresponding actions of the plaintiff's counsel. Granting summary judgment, one district court may properly look to another district court's determination that a particular demand letter was unreasonable and a legally insufficient predicate for insurance bad faith as a matter of law. In the Ninth Circuit granted summary judgment because on the undisputed facts, the insured's counsel's demand letter was itself unreasonable and appeared to be nothing more than an attempt to set up a potential bad faith claim. This was AAA Nevada Insurance versus Chow, a 2011 decision. You should read the full article, which goes on in the newsletter with details about the failures of setup, some methods used to set up bad faith, indicators of a bad faith setup, manufactured litigation, and how to avoid the bad faith setups. In addition, this issue of Zalma's insurance fraud letter contains an article describing a conviction for insurance fraud from the state of Delaware in a case called State of Delaware versus Paul Disabatino, which resulted in the conviction being affirmed. A listing of recent health insurance fraud convictions where various medical providers either were sentenced to jail or were caused to pay enormous sums as a fine or restitution, and other insurance fraud convictions dealing with every type of insurance fraud not related to health insurance, from crooked insurance agents to a fake life insurance claim. The issue also discusses my new book, It's Time to Abolish the Tort of Bad Faith, and other new books from Zalma's insurance claims library, including the insurance examination under oath, the books on insurance fraud, and Zalma's insurance videos. If you found this video to be useful to you, please view the entirety of this February 15, 2021 issue of Zalma's insurance fraud letter, which is available at www.zalma.com by clicking on the link to the Zalma's insurance fraud letter. Please convey this to your colleagues so that they can learn about the fraud letter and subscribe to the fraud letter, which will be emailed to you every 2 weeks. In addition, please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future postings and future videos. Thank you for your attention.